Hey, Paul Rabalais here again, and in this video I'm going to address whether the creation, funding, maintaining, and ultimate distribution of assets out of a living trust, whether all of that remains private. Okay, so sometimes you'll hear in a listing of the features or benefits of a living trust, you'll hear things like why people should have a living trust because they'll avoid probate, avoid court involvement, avoid delay, avoid attorney's fees. And then you also hear often in one of those kind of feature or benefits listing is all of your affairs will remain private. So I want to take a closer look at really whether all aspects of that living trust arrangement remain private. To do that, I first want to look at the last will and testament scenario and what happens when you leave things to others through your will and whether that aspect of it is private. So it really isn't, because after a person dies, if they had assets in their name and they used a will to provide for the disposition of those assets, one of the first things that's going to happen is their will is going to be filed into the public record for anyone to see. So a judge isn't going to allow any assets of the deceased to be transferred to heirs unless the judge has reviewed the will and confirmed that it's a valid will, and then the judge will explore ordering that assets be transferred pursuant to the will to the various third parties or those that are listed in the will. So that will is a public record after you pass away. The order that the judge signs ordering that the following assets be transferred to the following people, that is of public record. In Louisiana here we have a rule that says the detailed descriptive list, which is an additional pleading that's filed as part of the probate record listing all of the assets that the person owned and the value of those assets. The detailed descriptive list can be sealed upon the requests of certain people, but nonetheless the will, the judgment, that all is very much a matter of the public record for anyone to see. So let me give an example. Let's say Larry had a will. Let's say Larry had 3 kids, but for whatever reason, he only wanted the 10,000 shares of ABC Inc. stock that he owned. He only wanted that to go to 2 of his children, Linda and Tom. He didn't want his 3rd child, Thelma, to get any of that. So he puts that in his will. I leave my 10,000 shares of ABC Inc. stock to Linda and Tom so that they can share it equally, 5,000 shares apiece, however it's written. And then when Larry dies, his will gets filed into the public record for all, including Thelma, to see. Thelma then realizes that, she got less, or whatever the case may be, than Linda and Tom because Larry excluded Thelma from that bequest. So now let's take a look at whether the aspects of a trust remain private. So the way that works is many people use a trust instead of their will to provide for the disposition of what they have, because assets titled in the name of your living trust don't have to go through the courts to be transferred. The way it works, Larry would establish his Larry Living Trust. He would retitle assets that he owned, including his 10,000 shares of ABC Inc. stock, to the trust. And then when Larry dies, you see Larry in his trust named a successor trustee of his trust. Let's say he named his son Tom as the successor trustee, and he would name beneficiaries of his trust who's going to receive the trust assets when Larry dies. And in Larry's trust, Larry happened to say that when Larry dies, those 10,000 shares of ABC Inc. stock that are titled in the name of Larry's trust are to be transferred from the trust by the trustee to Tom and Linda. And so that's what the trust says. And then when Larry dies, Tom, as the successor trustee, he'll go to the financial institution or the transfer agent of ABC Inc. stock, and he will be permitted to transfer those shares from the trust, 5,000 shares to Tom, 5,000 shares to Linda. All of that remains very private, with nothing having to have been filed in the courthouse or the public record in the county or in Louisiana parish where Larry lived when he died. Now, on that aspect, now, why do people want to keep things private? For a number of reasons. Sometimes people don't want certain family members to know of the existence or of how the person wanted things disposed of. So they'll want to get the benefits that a living trust offers in terms of privacy. Some people fear that maybe creditors potential creditors may prey upon the estate if all of the estate information is of public record. Some people for business reasons, some people because they fear that Big Brother is watching. They just want to keep as much as they can out of the public records. Now, a little bit different though if Larry owned real estate. So there's just an exception to the privacy rule when it comes to real estate. So let's say in addition to the 10,000 shares of ABC Inc. stock that was in Larry's trust, Larry also owned a home. And he transferred his home to his trust because he didn't want the transfer of his home to go through probate when he died. And now when a trust owns real estate, and again, this is the Louisiana rule, but I think most, if not all states have some rule requiring some public disclosure of information if a trust owns real estate. And I'm going to give you the Louisiana rule. So if a trust owns real estate, then the trustee must file what's called an extract of the trust in the parish. We have parishes where the property is located. What's an extract, you might ask? Well, an extract is a document that includes certain pieces of information. You see, if Larry's trust owns Larry's real estate and Larry wants to sell his home, the buyer's title examiner needs assurance that Larry has the authority to sell the home from Larry's trust. So when a trust owns real estate, you have to file certain information into the public records. That extract that must be recorded must include some information. It must include the name of the trust, a statement as to whether the trust is revocable or irrevocable. The extract must include the name of each settlor, that's who set up the trust, and it also must include the name of each trustee and name or other description of the beneficiary or beneficiaries. It must also state the date of execution of the trust. And then it must also provide any limitation or restriction on the power of the trustee to alienate, lease, or encumber immovable property contained in the trust instrument. Okay, so if the trust owns real estate, that extract, you could file an actual copy of the trust, but that's usually many pages long, and that extract is usually 1 or 2 pages long, often just 1 page long. So that's just easier, and there's less information in the extract than there is in the trust instrument. So when a trust owns real estate, the extract must be recorded in the parish, and the information included in the extract is of public record. Now, if Larry wanted to go to the next step and be a little more creative, maybe he could create trust number 1, which would own his real estate, and everything related to the trustee and the beneficiaries of trust number 1 would be of public record. And then he could have trust number 2, which owned everything other than Larry's real estate, and all that would remain private. Or sometimes people get creative where their trust owns an LLC and the LLC owns the real estate. So the trust doesn't own real estate, the trust owns an LLC that owns real estate. But that's, kind of those strategies are beyond the scope of this video. I think with what I just mentioned, will is a very public matter. Trust is typically completely private unless the trust owns real estate. Then the information required to be in an extract is going to be available to third parties out there. And I think that information should satisfy probably at least 95% of you who are out there wondering if all aspects of a living trust remain private. Okay, a couple more things that are really important. 1, make sure you smash the like button. 2, make sure you hit the subscribe button and the notification bell so that the YouTube algorithms will keep my estate planning videos in front of you as you go to the YouTube channel or YouTube website from time to time. Feel free to include any constructive comments below. That would be awesome. Everybody likes those, and we like to see those. And then we'll see you next time. Take care.